Good evening and welcome to the Indian River County Planning and Zoning meeting of October 27th. Please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. First item on the agenda is the approval of the minutes.
So moved.
Do you have a second?
Second.
All in favor say aye.
Aye.
Opposed? Motion carries. Commissioners' matters. Anybody have any commissioners' matters? Okay. Planning matters. We have an update, a status report on the Ocean Concrete project application.
Yes, Madam Chairman, Stan Bolin, County Planning Director. Previously, staff had informed the Planning and Zoning Commission that an appeal had been filed by George Mabe related to the Ocean Concrete project, and this evening, we just simply wanted to update the Planning and Zoning Commission. You have the staff's report and some attachments in your backup on the status of the appeal. In that report, staff had given a very brief outline of some of the site plan application and changes to the IL district type of timeframes, because we're aware that some of the Planning and Zoning Commission members now serving weren't on the Planning and Zoning Commission at the time that those items came forward. Some new information has come forward in the last few weeks regarding the ownership of the property, and it affects the status of the appeal and the timing of the appeal. And I'd like to turn things over to the County Attorney, Alan Plakowich, to give you an update on the ownership of the property.
Yes. Basically what's happened, as you all know, back in May, the Community Development Director issued a letter denying a site plan application by Mr. Mabe. He did that in large part based on an opinion from me on vested rights, reaching the conclusion that Mr. Mabe did not have vested rights to the application of the pre-existing zoning laws. Mr. Mabe took an appeal of that process at the beginning of the summer, and I know that you've been informed from time to time that this is coming. And that's really why we brought it on an informational basis today. The problem that's been happening is while this appeal is pending, Mr. Mabe has also had some other proceedings going on. He has a foreclosure case that was filed against him and a bankruptcy that he chose to file. The foreclosure case came out of the bankruptcy because foreclosure cases are stopped by bankruptcy. It came out of the bankruptcy, I believe, in April of this year. The creditor, lender in that case, went ahead and requested the foreclosure court to order a sale of the property. That was held on July 7. Normally, the deed, and in fact the lender, LNV Corporation, was the high bidder at the sale. Normally, following a foreclosure sale, in a fairly brief time, the court would go ahead and issue a deed to the successful bidder, in this case LNV. However, what happened, Mr. Mabe filed some objections to the sale, and the foreclosure court had to decide and work its way through those objections. So while we've had this appeal pending, we've simultaneously had this process ongoing that appeared that unless Mr. Mabe's objections to the sale were upheld, he was going to lose title to the property. So we kind of went forward to the process, and in September basically got tired of waiting for the foreclosure court. So we said, well, let's go ahead and schedule in front of P&Z the appeal and just see what happens between now and then. So we went ahead and proposed some alternative dates to Mr. Mabe, and eventually we were aimed at this date, October 27. But then what happened is we were getting ready to schedule the appeal hearing. the foreclosure court entered its order denying Mr. Mabe's objections to the sale and directing that the U.S. Marshal go ahead and issue the deed to LNV Corporation. So we're now in a situation, we checked as late as this afternoon, and we could not find whether or not that deed has been executed or not by the U.S. Marshal. But the bottom line is, it appears that it is imminent that Mr. Mabe is going to lose title to this property. When that happens, under our code, he cannot proceed with a site plan application because he will no longer be the owner. So the only way he can proceed is if he has written authorization from the owner, and we don't know if he'll be able to get that or not. So we decided that rather than go through the appeal hearing, which is a pretty arduous process here, while it appeared that Mr. Mabe is about to lose title any day now, we decided to bring it forward on an informational basis. So that's where we are. Our plan at this point, our expectation is that the deed will issue to LNV any day if it hasn't issued already. When that happens, our plan will be to go to Mr. Mabe and basically say, you know, you're no longer the owner of this property. Under the code, you no longer are in a position to move forward on a site plan application. We will give you 30 days, if you wish, to try to get written authorization from the owner. If he does, we'll come back here and hear the appeal. If he doesn't, then I believe the appeal has become moot because there's no way at this point the P&Z could grant an application to someone who no longer owns the property. So that's kind of where we are. We decided to bring it back on an informational basis and follow the foreclosure court to see when the deed is issued. And then, as I say, take the action of giving Mr. Mabe the opportunity to get written authorization from the new owner.
Okay, so this is no more than a status report, so no action to be taken. So let's move on to the upcoming P&Z meetings.
Do you want to do the affordable housing?
Can you guys give the public an opportunity to speak on this?
No.
Since you're updating George Mabe's rights, I think George Mabe should
No. It's not a public item. It's not a public item.
This is just a status report. This is not the appeal. This is nothing. This is just telling planning and zoning where we stand on this issue. And it's not before us now for any action whatsoever. It's just a status report to say this is where it is and this is why it's not before you tonight. That's all it is. But I'm sorry, if you're going to...
I mean, it's 4 years and the man hasn't gotten a hearing.
Wait a minute.
Ms. Chairman,
please.
as an opinion, and just to reiterate for yourself what she's saying is I understand what you're here, you're upset, whatever, but you know what? We've got other issues here tonight, and this is not a public hearing. They do not have to speak from the public. If you continue to speak, then it's just not, you're a disruptive to the meeting. So we'd appreciate letting us move ahead, period.
Commissioner Hamner, I do intend.
I'm not the chairman. If I was, I might be asking for the sheriff. So I wouldn't push the point.
What is your name, sir?
Jeffrey Smith. I'm an attorney for Mr. Mabe and Ocean Concrete, and I just would be very brief and simply say we do object to the fact that the appeal hearing for this evening was canceled. Mr. Mabe invested a lot of time, effort, money to have witnesses and to present a proper appeal. That has now been denied him. And so I just wanted for the record to reflect
It's
that
not on
we
the record.
object to
There's
that.
no record.
Okay, thank you very much.
There is no
Mr. Smith.
record.
I think there's a video record.
Okay. Thank you very much. I will repeat, this is a status report that has been presented to Planning and Zoning tonight by staff. No action to be taken. Next item on the agenda.
All right, the next item is on upcoming Planning and Zoning Commission meetings. As you know, the schedule in November and December is a little different because of the holidays. And we have the next two meetings that are scheduled to occur is November 10th, and then after that, December 8th. Now, on November 10th, we understand that Ms. Keyes and Mr. Hamner might not be here for the November 10th meeting. We've informed applicants that want to be on the November 10th meeting that, there may only be 5 Planning and Zoning Commission members. They were fine with moving forward, so we actually have a pretty full meeting and pretty full agenda for November 10th. There are actually 3 special exceptions. One of them we think is not controversial at all. A second one, we're not sure. And the last one involves Indian River County Recyclers off of 74th Avenue, south of Oslo Road, and we think that one will be controversial. Nonetheless, we will have at least those 3 items for the November 10th meeting, so we think it, make sure you eat or bring a snack, before coming. December 8th, Planning and Zoning Commission meeting, we believe we will have a special exception application for that meeting, and I just want to let you all know what's coming up on the next couple of meetings. Does anyone know that they will not be able to attend the December 8th meeting?
I'll be here.
Okay. Looks like we'll have a quorum then.
That's great. It's a bar holiday.
Dan, I am sure I won't be here on the 10th.
Okay. Understood.
I'll be in Japan.
I understood that.
Right.
I have to check the schedule for the 10th as well. I'll be able to confirm that this week, tomorrow.
Okay, thank you. I appreciate that. One other item under planning matters that I did want to bring up was there is still an Affordable Housing Advisory Committee, although it doesn't meet as often as it used to. Some of you may be aware that the Planning and Zoning Commission has a designated member that serves on the Affordable Housing Advisory Committee. Jerry White was for a number of years. Greg Smith was, and Greg Smith served as the Planning and Zoning designee through the end of 2010. There was a meeting in May of this year, and I was unaware that of the lapse in Planning and Zoning Commission designation. So I would like the Planning and Zoning Commission to designate a representative for the Affordable Housing Advisory Committee. They are looking to have a meeting on November 16th, and I understand that Jens Tripson may have an interest in serving in that capacity, or at least have no objection to serving in that capacity. And Madam Chairman, I'd appreciate it if the commission could make a motion designating one of the members here to serve on the Affordable Housing Advisory.
Mr. Tripson, are you willing to take this position? I am. Okay, thank you. Can I have a motion?
Anybody else want it?
Do I vote?
No, motion to approve Mr. Tripson.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you.
I would like to put in a plug, if possible, speaking of affordable housing. On November 5th, Every Dream Has a Price, which is a not-for-profit affordable housing entity in the county, is having a fundraiser at Vero Beach Sports Village. There's going to be a barbecue competition and 2 softball games, one which is guns versus hoses, which is law enforcement versus the firemen, and the other is government versus celebrities. It all starts at noon on November the 5th, so please come out.
Okay, thank you.
Put it in the plug.
Okay, attorneys' matters?
Yes, Madam Chair. We have a matter before you today for action if you choose to do so. Basically what's going on here is when I sat through the first significant quasi-judicial proceeding that the Board of County Commissioners held, which was in the A1 Wall-E matter, and actually as I started in that entire process, it became clear to me that a fair amount of effort was being spent by people involved in the process just trying to figure out exactly how the process worked, particularly in a contested case where there were going to be people arguing multiple different positions. So, and I know at that time the chairman had me prepare some paperwork for him so he could handle that hearing with some level of knowledge and understanding. Well, after we finished that process, I reached the conclusion that we would all be better if we had some quasi-judicial guidelines that when we have one of these proceedings that's coming up, we can hand that out to each of the participants or each of the attorneys and tell them exactly how we're expecting this process to work. Everyone will get on the same page procedurally, and I think as long as everybody's on the same page procedurally, the chances of an error happening, I hope, are reduced, or at least you're narrowed down just to the substantive issues and you don't get off track based on the procedural stuff. So I prepared some quasi-judicial guidelines, which I brought to the Board of County Commissioners early this year, They looked at them in August and then adopted them by Resolution 2011-69 on September 6, 2011. So these are now, and they're in your board package, but these are now the guidelines that are governing quasi-judicial proceedings before the Board of County Commissioners. You'll see in the resolution, the board certainly didn't want to preempt this commission and its choice of procedure, but on the other hand, the board did invite this commission to take a look at these guidelines, and if you consider them appropriate, adopt them, or if you choose to amend them, that's fine, or if you choose not to adopt them, that's fine as well. But I believe they're here tonight for your consideration, however you choose to act with respect to them. I can go through them if you want. I don't know if you're familiar with them.
Mm-hmm. Do we have to take, we don't have to take any action on this, do we?
Well, if you want to adopt them at some point, you can adopt them tonight.
Okay.
You could adopt them at some point in the future.
Well, these have been adopted by the BCC, right?
Correct.
Okay.
I have a question about it, and it may direct to it or not, but I called a friend of mine at his office earlier this week, and the secretary said, are you ready for the red shirts? And I said, what do you mean? And she said, well, we're going to be coming for what used to be A1 Wally. Now, do I need to get her name and send that to you?
Well, I'll tell you,
Repeal the sunshine.
you don't have to do anything on verbal discussions,
Okay.
except when you get to the hearing itself, you will be asked to disclose any verbal discussions that you had.
Okay.
So you would be asked to disclose that.
Okay.
If they gave you, under these guidelines, if the person gave you something in writing, if you don't read it, then you don't have to worry about it. If you do read it, then under the guidelines, you would give a copy to Stan and Bob so they can keep it in the public file, and it would be part of the disclosure.
I just didn't know how long, how far we took it, where I don't know the woman's name, and we didn't discuss anything. She just said, are you ready for the red shirts, and said what it was, and I said, oh, I don't know. So.
I do have one question. You've indicated that if we visit a site, that we have to make notification that we visited the site. And I'll be quite honest, any commissioner who has not visited a site, I think should be embarrassed by that. So why do we waste time telling people we visited the site? I mean, that's 7 commissioners you got to go through saying, yes, I visited the site. No, it didn't change my mind.
The reason is, actually, there's a statute that governs part of this process, and we're trying to make sure we comply with the statute. The statute itself has a section that says local public officials may conduct investigations and site visits, and may do a few other things. Such activities shall not be presumed prejudicial if the existence of the site visit is made a part of the record before final action on the matter. So in other words, the statute presumes that if you take a site visit and reach some kind of conclusions as a result of your site visit, that could be prejudicial to the person against whom those conclusions might be drawn.
If at our level we wanted to exempt that from our guidelines, can we do that? Or are you struggling with that because of the law?
Yeah, I've got a statute here that basically says it will be considered prejudicial unless you disclose it. So on a piece of these guidelines which is directly covered by the statute, I would suggest that.
Does this disclosure have to be public, or can it merely be an email to Stan and staff saying, I've been to the site, I'll see you at the meeting?
Well, what you could do, you could put that in an email to them. They would put it in their file, and under the guidelines, they then give those documents to the clerk. So at that point, they become part of the record.
Alan, when you read the statute or part of it, didn't it say if the visit made you decide one way or the other? Something along that line? That if it
Well, it says that it shall, the way they've stated it is in the negative. They said the visit shall not be presumed prejudicial if the visit is made a part of the record prior to the final action.
But I thought I heard you say something in there about that if it made you make your mind up, if the visit was a determining factor, something at
that's literally my embellishment of the language in the statute.
Okay.
The statute solely says site visit.
Right. Period.
Period.
Okay.
Okay, so
We'll never break the 2-minute rule the 2-minute goal of the meeting again, George.
I'm just wondering if, it's just, procedurally, we used to have a little checklist for the chairman. I guess if we're going to do that, we need to make sure we maintain that. That, did you go, or, maybe simply the question and, can we do it by show of hands? I mean, could you just, because I think what Donna's saying is that you really, probably, most people do go often. Mm-hmm. Sometimes several times.
Yeah, you could do site visit by show of hand. In terms of actual communications that you have, there's a requirement in the statute that you address the subject of the communication and the identity of the person with whom you had the communication. Okay. So a show of hands wouldn't work on communications.
Right, I understand.
But it would work on the site visit side.
Okay, would you do me a favor, Alan? Would you come up with some specific wording that we are supposed to say before every quasi-judicial thing, so that it's just there, it's the same thing every time we have one, the wording is the same, the request of the commissioners is identical. Anybody who has visited the site, please raise your hand. Hey, raise your hand. Okay, and all those who have visited the site, is there anybody who's been prejudiced by that visit? Raise your hand. Okay, nobody raises their hand, fine, on to the next thing.
Yeah.
Now, any ex parte.
Prejudice, do you?
Yes,
well,
that's part of it.
In the end,
if you disclose it.
In the end, we're going to be looking for each commissioner who's done one of these things to confirm that they have an open mind with respect to the matter and can base their decision on the evidence and the applicable law. Okay. That, in the end, is going to be kind of the ending point of that disclosure process.
Right.
Okay, a standardized wording.
Sure.
Just a little thing that we say at the beginning of every quasi-judicial meeting, and it just becomes part of the record that way.
Yes.
Okay?
And is there a definition of a site visit?
There is not a definition of the site visit. So I think basically if you go there and look at it, you have conducted a site visit.
You ride by on the road.
What about GPS, though? I mean, Google.
I mean, Earth.
Google Earth. Yeah, that's a good question.
Virtual site visit.
Virtual site visit.
I think
well, it's going to be coming.
Yeah.
It is. I've looked at it.
That
Google
same
Earth,
statute
absolutely.
that I just mentioned, included in the word, you have site visit as one of the things. Another is an investigation. Frankly, if you go on Google Earth and start looking at things, that'll probably start becoming an investigation.
I would suggest that you include that as well.
Yeah.
That's why I think specific wording for us that you wanted to see said at the meeting would be really helpful.
No problem.
Okay, thank you. So, do I have a motion to approve the quasi-judicial proceedings as stated in
Do you want to?
this resolution 2011-069?
I have no problem with this. It's the Board of County Commissioners has already approved it. We probably ought to live with it. The only reality is you got 3 people missing. If they have any comments, or if you want to wait till we have
Hey, if you don't show up, you know what happens.
We do have a quorum.
We have a quorum.
So moved.
Okay.
Second.
All right, all in favor, say aye.
Aye.
Opposed? Motion carries. Thank you. All right, any further matters? Meeting's adjourned. Thank you.
Thank you.